The 261st is back in session.
All right, very good. That took a little longer than I thought it might, but I'm happy to give you the time to get more organized. And so I'm ready now to begin opening statements. Ms. Burgess, you may proceed first.
Thank you, Judge. May it please the court, counsel. This is something I've said many times in front of judges and juries in my career, and that is that a deal is a deal. In this case, can you see my, they can see my screen, right? You can see my screen, right? It's on a different setup here. So a deal is a deal.
I can see your screen, and I'm assuming if I can see it, that everyone else can as well.
So the deal that was made here was between Willie Saylor and Flow Sports. And it was a deal that he wouldn't compete for a year after he left, or of course that he wouldn't compete during his tenure, which he actually weighed in on competitive strategy for Rockfin 9 months before he left Flow Sports. He agreed not to solicit Flow Sports subscribers or customers, not to disclose Flow Sports proprietary information or the confidential information of third parties, all of which he's done. He agreed to return Flow Sports information upon his exit. And the evidence will show, of course, that Martin Floriani signed that deal for Flow Sports, both as a fiduciary and in response to requirements, obligations imposed by Series A investors. Now, not only did Saylor breach that contract, but he took Flow Sports trade secrets, and he admits that he continues to use those in his work for Rockfin today. Rockfin wrongfully interfered with that contract. In February of 2019, 9 months before Saylor left Flow, Martin Floriani began recruiting Saylor to work for Rockfin. Mr. Saylor immediately went into the idea that he should flip Flow Sports live stream contracts from rights holders over to Rockfin. Rockfin said that they needed Saylor. He would be the flywheel that would build momentum for Rockfin. That's what he said, the flywheel. And then Rockfin tirelessly pursued Saylor for the ensuing 9 months. And they weren't wrong. This is a publicly facing dashboard where Rockfin talks about its subscribers. The evidence will show that Rockfin's subscriber base doubled when Saylor joined. All wrestling subscribers, most of Rockfin is wrestling. He joined Rockfin as a W-2 employee, and Rockfin continued to pay his benefits through September, just last month. They were still paying his benefits, and they say that he's completely independent. He did so with 8 years of data that he took from Flow Sports, where he was a Flow Sports employee. Now, once they got the flywheel going and a critical mass of wrestling subscribers had signed up to Rockfin, this summer, another valuable rights holder called Nittany Lions approached Willie Saylor about streaming its events on Rockfin. And that rights holder had been negotiating with Flow Sports, but chose Rockfin instead. Still, they say they're not a competitor. And the flywheel worked again. With that critical mass of wrestling subscribers, Rockfin got this live event that again doubled their subscribers. That was the exponential effect, and it was a value that should have remained at Flow Sports if the defendants had honored their obligations. We'll go quickly through the players because you're familiar with a lot of these, but Rockfin defines itself as a digital sports media company. Flow Sports, of course, has been in that business for over a decade. The same business, they provide the same thing Rockfin does in terms of you buy your subscription to Rockfin or you buy your subscription to Flow Sports. You watch wrestling content, both live events and rankings, recruitment, other things behind a paywall. Flow Sports has about 260 employees and has about 26 to 30 verticals, which is what they call their sports or competitions. Not all of them are traditional sports. Some of them are different kinds of competition. These are folks from Rockfin. We have deposed and plan to present their testimony. Of course, you know, two of these Mr. Floriani and Mr. Saylor, who's a defendant. He was the former managing editor for Flow Sports and former head of recruiting for Rockfin, and they turned him into a kind of a contractor after this lawsuit was filed. Mr. Augustine is their corporate representative, and Mr. Velikat is their head of marketing, who uses Facebook, pays for ads for Mat Scouts, which is Willie Saylor's trade name, pays for ads and targets Flow Sports in the audiences. And they say they're not a competitor, and yet they're paying to target Flow Sports audiences in order to advertise. These are the folks you're going to hear from from Flow Sports. You've seen a little bit about them in the motion to exclude, so you already know a little bit about what their backgrounds are and what they're going to talk about. These are the two individuals the defendants have, former employees of Flow Sports, the defendants have said that they're going to subpoena. And these are the two experts. We talked about Mr. Wolk. He wrote a book about over the top, going direct to consumers. And he knows the competitive landscape in this over the top media world. In particular, he's going to talk about the competitive landscape with regard to sports. And then we have right here in River City, right here in Austin, Texas, Jared Jordan, who has very conservatively analyzed the damages that have been suffered as a result of the defendant's misconduct. Quickly through hitting the highlights of this timeline. Of course, the PIIA was signed in 2014. You've seen this document before, and there will be a lot that we're going to focus on as we look at it. But basically, we'll start with the non-compete. And the non-compete has three distinct obligations. Not to compete. It's got three Romanettes. Not to compete, not to participate in the management, operation, or control of any competitor. And it includes, competitor can be a person or an entity. Here, at a minimum, Mat Scouts, Willie Saylor's trade name and channel, fits that bill. And number three, not to perform the same or similar duties for a competitor. The business of the company is providing products and services. They agreed that Flow Sports was in the business of providing products and services in the sports video industry. That's live events, that's streaming, that's content, that's all the things that Flow Sports was doing at the time. There's also a non-solicit, and there's also a confidentiality provision that has been breached here. Of course, Flow Sports built Saylor a studio. They flew him all over the world to cover wrestling. They built him up from 100 Twitter followers to 22,000 Twitter followers. He agreed not to solicit. He agreed that the company had a right to enforce by injunction, and that injunction wouldn't start until he stopped competing. That hasn't happened yet. Unfortunately, the TI did not prevent him from doing anything except live talk shows. He said in his testimony at the TI that he thought all you were preventing him from doing was live talk shows. And you could have done that in one paragraph, but he can find a truck to drive through every carve out in that injunction. And it also acknowledges that the time, geography, and scope of the non-compete is reasonable. Confidentiality applies to both information he learns from Flow Sports as well as third parties like coaches and rights holders and other individuals that he has disclosed since. This is important because there are no fewer than 3 different anti-waiver provisions in this contract. And I think you probably saw this when you reviewed the other motion, but they cannot waive without a writing. So to the extent that there is a waiver argument, that evidence should not come in, and certainly it could not remove the obligations under the contract. Of course, there's a merger clause. You know, I like to call it, this is the deal is a deal paragraph. It's not unusual for parties in litigation, particularly competitors, to be unhappy with the deal they made and think that maybe they decided it meant something different, or God forbid, they're unhappy with their opposition. That usually is going on at some point during litigation. But they can't avoid the consequences of their deal by alleging that the opposition is enforcing its contract in bad faith. That is not that is not a legal position. There are contracts and they are enforced. Saying that it's unfair to enforce it is not a legal defense. And it's not true either. Flow Sports invested heavily in Willie Saylor. Martin Floriani, again, began recruiting him in 2019. There's the letter. They wanted to click through text because they didn't want these to be on YouTube, despite the fact that they will be admitted and they actually are already public records. But suffice it to say that Willie Saylor and Martin Floriani had many texts during this time, including Willie Saylor calling Martin Floriani his God, saying he was going to explode, and going on and on about hero worshiping Martin Floriani and how he couldn't wait to go join him. And Martin Floriani kind of, then Saylor would say, no, he's not going to join. And then Martin Floriani would continue to pursue. And then ultimately he did. Let's go to that one. Here's a text that Mr. Saylor had with a third party named Bashada. He said that he's sort of, this is when he left Flow Sports, sort of intimidated that going to Rockfin might be against my non-compete. If they fight, I'll put them on blast publicly. Well, that was the roadmap for what he did when Flow Sports enforced its legal rights. That was from Willie Saylor on 11/5, the day of his exit interview, when he finally told Flow Sports that he was going to Rockfin, and they objected to that. On November 1st, Martin Floriani traveled to Pennsylvania to meet with Saylor, and the next day made him a formal offer. During the course of that time, Rockfin had persistently pursued Saylor as a flywheel. And also over the course of that time, the defendants have admitted judicially in summary judgment filings that Saylor continued to receive valuable trade secrets that entire time. After he quit Flow Sports on the 2nd, when he got that offer, he accessed Periscope, our most valuable dashboards and content attribution system. He tweeted out confidential salary information and threatened to tweet out more. He told Christian Piles, who was his colleague and friend at the time at Flow Sports, he said, I told you I wasn't going to compete, but what did you think I was going to do? Be a school teacher? Of course I was going to compete. He admitted in text to taking down Flow Sports rankings and posting those rankings on Rockfin. And he did that. And he also accessed Flow Sports rankings spreadsheets that he had spent 8 years developing at Flow Sports as part of his job. He used them right away. So that was his Flow Sports Google Suite. That's how they keep that's the Flow Sports system. And they keep it on Google Drive. And he exported all of his rankings work, all the work he'd been doing at his desk for 8 years for Flow Sports. And 3 days later, he's got them up on his screen open so that he can do rankings for Rockfin. Now, I don't think that if the court had known that, there would have been a carve out for rankings. Saylor admits that he does the same or similar duties at Rockfin that he did at Flow Sports. The only one that's changed since the TI is talk shows. He admitted at the temporary injunction hearing that what he was doing was competition in a certain sense, for sure. I mean, there's no doubt about it. And he admitted that he wanted subscribers to follow him to Rockfin, and that is what happened. This was your question, Judge. When you entered the temporary injunction, you made a carve out because of you made some carve outs because of the First Amendment. And as you know, Judge Jenkins considered that at length, and the parties briefed it at length, and that was found to not be an issue. Saylor's stock options were then revoked. The stock option agreement allows for revocation even for, so you have 90 days to exercise your options. As you know, options are not a property right, they're a contract. You have 90 days to exercise them. in that 90 days, if you do something that would constitute cause for termination, then they can be revoked, and it's in the absolute discretion of the board. Well, here, not only cause is defined, and he pretty much hits everything in this entire long paragraph, taking our information, competing, he meets all of it. And so the options are properly revoked, but he has sued for that. It's also notable that this is under Delaware law, so there would be no fees, even if he was a prevailing party on that. Rockfin says they're not a competitor. They say they're like YouTube or Twitter, and yet they require pre-approval before you can start publishing. They provided Saylor his studio equipment and paid for it. They helped create his brand and logo. They created his signature. They pay for ads for him. They tag him in posts. They have a non-disparagement and confidentiality agreement with him. They provided him health insurance until last month, and they're paying his attorney's fees. So it's really hard to say it's just independent. Notably, when they pre-approve you for Rockfin, they only have 120 providers on there. And they say that sometimes a provider is ungiven publishing, this is their words, ungiven publishing rights because they don't like the content. And so if you're not giving, they're curating the user experience as well. This is the Facebook ad they created for Saylor using Flow's images. These are the ads that they put up and all the publishing that they're doing. Like I said, these are the ranking spreadsheet that he took with him. These have caused damages, of course. At the temporary injunction hearing, as defendants often do, they say, hey, this is compensable in damages. You should either do nothing on a temporary injunction or limit it, because these can be determined by the metrics at Flow Sports and Rockfin. And that is true. And we know that value went over to Rockfin. Mr. Jordan will tell you about the lost profits, the loss broken down into 3 buckets, as well as he's not going to testify to disgorgement. That's based on the defendant's exhibits. But there's also exemplary damages, attorney's fees, and injunctive relief that should be granted here, both under the Uniform Trade Secret Act and the contract itself. Saylor knew the deal in this case. Rockfin knew the deal that they made. And the deal was there specifically to protect Flow Sports from unfair competition and from misappropriation of its confidential information. So is the Uniform Trade Secret Act. But the defendants could not resist the head start, the flywheel that they got. And so they dishonored the deal. They unfairly took a competitive advantage, acknowledging frequently, you're going to see this, and the evidence is going to show a lot of times that they acknowledge that they know not only that it violates the non-compete, but that they will get sued for it. Still, throughout this entire year, they've ignored this court's authority in the injunction. We respectfully request that the court hold the defendants to the deal, hold them to the statute, hold them to the common law, and we appreciate your consideration. I think I gave back 2 minutes, sliced it in half.
All right, thank you very much. Maybe it's a good time for us to establish the order in which we're going to hear evidence and argument. And really that's something that Mr. Soltero and Ms. Dickey can tell me how they want to go, but I'd like to go in the same order all the time. So which of you would like to follow? Does Mr. Saylor wish to go first, or does Rockfin wish to go first?
I mean, Ms. Dickey, did you want to go first if we're going to do that throughout the trial, or do you want me to go first?
Your Honor, we will do that, of course. We had divided the witnesses up a little bit differently. The witnesses that have more to do with Mr. Saylor, we were going to have Mr. Soltero go first, and the witnesses that had more to do with us, we were going to go first. But if you want us to establish an order, we'll do that.
Well, I would like to establish an order so that I can keep things flowing and I know who's following who and so forth. But if it won't change what you're planning, you can call a witness and he'll just pass and go on, and then he'll come back to him. It's not going to be it won't substantively matter, but in terms of the ease of proceedings and to keep everybody straight, I'd like to go in the same order. And it doesn't
Okay.
matter to me what that order is. What's your preference?
I'll go first. How's that?
That's fine. You're up.
Okay, let me set my timer. Thank you, Your Honor. May it please the court, counsel. The evidence will show in this case that Martin Floriani founded Flow Sports with his brother Mark in 2006. And then he served as the CEO until he was removed from that position in February of 2018. And then as a board member in May of 2018. It's really important for the court to understand that Mr. Floriani, his wife and children, are still the single largest shareholders in Flow Sports. And therefore, it's in his best interest for Flow Sports to succeed. Martin Floriani, I think the court knows enough now to know that he's a man of ideas and energy. As soon as they removed him, kicked him out of Flow Sports, he did start working on a new idea. And during the second half of 2018, he teamed up with Scott Augustine, who you will hear from, and others to build Rockfin, which launched in late March of 2019. Rockfin, so the court has some context, is a content neutral technology platform. And I've had to learn what that means. And it means that it allows content creators in a variety of subject areas, from politics and comedy to sports, to publish their own content and broadcast their own events on Rockfin channels. And I've actually looked at it, and we will demonstrate that, in fact, there's left-wing politics, right-wing politics, all kinds of comedy in addition to sports. Rockfin itself does not publish content. They don't publish articles, they don't write articles, they don't do rankings, they don't have podcasts, they have no live events that Rockfin puts on. Rockfin also does not purchase the rights to broadcast events, which is very important, Your Honor, because that will be shown to be the core business of Flow Sports. Like other platforms that passively have a platform that hosts user content, Rockfin is registered with the US Copyrights DMCA directory, meaning the company is not liable for content published on the platform. Only websites that aggregate content from users in a non-selective way are eligible for DMCA protection. One of the facts that you'll hear a lot about is blockchain. And that is Rockfin's advantage over its other competitors like Patreon, Substack, and YouTube. Other websites that passively host user content is its blockchain component is the critical distinguishing feature. Content creators like Mr. Saylor and NatScouts are compensated for the value that they bring to the Rockfin network in what's called Ray tokens, which you'll hear quite a bit about. And much like stock, Ray tokens increase in value. And as they increase in value, of course, so does the cash equivalent value of Ray tokens. Flow Sports today has made it, and throughout this and in many of their interrogatory answers, has made it crystal clear that Mr. Floriani was aware of Mr. Saylor's PIIA as Martin countersigned on behalf of Flow Sports. He was aware of it, he countersigned it, and it's undisputed. But the evidence will show that Mr. Floriani had a good faith belief that Rockfin's business relationship with Saylor would not violate any contractual obligations that Saylor owed to Flow Sports. Indeed, Mr. Floriani believed that the non-compete did not prevent Saylor from expressing his opinion as a journalist. And he believed this, Your Honor, at the time. That's the understanding that he had when he entered into that non-compete with Mr. Saylor as the CEO of Rockfin. Evidence is going to show in this case that neither Matt Scouts nor Rockfin is a competitor of Flow Sports, as that term is used in the PIIA, an entity in the sports video industry that you're going to hear about till the cows come home. As such, Rockfin did not and is not willfully and intentionally interfering with this contract. And that line right there, willfully and intentionally interfering with the contract, is an essential element of tortious interference. For its part, Flow Sports' most recent position is that sports video industry is an ever-evolving concept that covers anything Flow Sports does or has ever done in the past. Indeed, Mr. Machuca, who is their corporate representative that you will hear from, testified that the word onion could have been substituted in the spot of sports video industry, and it would have the same meaning. Whatever Flow Sports does. I'm not making that up. He said onions. As such, their position is that Flow Sports considers Olympic governing bodies, local and national print and online publications that do not have any video, sports PR firms, casinos as competitors. Despite this overly broad interpretation, the evidence will show that Flow Sports has not once labeled Rockfin a competitor, not in any marketing decks, which will show you, not in emails with competitor apps, not in board decks, and not in fundraising rounds. The exception, of course, is this lawsuit. Which brings us to this lawsuit. This lawsuit is a pretext, Your Honor. Flow Sports would have the court believe that it's a colossal effort to protect its trade secrets and enforce its written agreements, that all they want is for Mr. Floriani to honor his obligations. But really, this is a weaponization of the litigation process to drain Mr. Floriani and Rockfin of limited resources and to control a former employee with whom Flow Sports management experienced persistent conflict. Indeed, Flow Sports has spent more than $1 million on legal fees in this effort, which has completely soured the company's reputation in the process. We've heard some about that in the past. The evidence will show that Flow Sports has taken an overly broad and unenforceable meaning of the PIIA and bullied Willie Saylor. Flow Sports holds its agreement in this lawsuit over the heads of even those they fire to keep them from joining Rockfin. This is against public policy and not permitted by law. The pretext is obvious given that many former employees of Flow Sports who have left and done exactly what Willie Saylor has done, which is to write and post about sports they covered at Flow Sports, have not been sued. The only difference is those former employees, Dutch Taylor, Todd Brasley, Joanna Gretschfield, Hunter Homestek, and Dan LaBelle do not have a channel on Rockfin. And this is really important in terms of what we were hearing earlier, Your Honor. This isn't about some kind of waiver argument. This shows what they believe to be, what they believe the competition was, and it goes to the whole damages component of this. Because if they're allowing everybody else to leave and they would say compete, and incur, I mean, they can't be doing that. They would be allowing people to compete and they would incur damages. The case in point that will show, Your Honor, is that a former employee named Dan Lobdell, also known as the Wrestling Nomad, is writing about wrestling and ranking wrestlers on Patreon, Rockfin's competitor. Not only is he continuing to write and rank on that about wrestling on that website, but Flow Sports has actually promoted his writing and ranking on the Patreon website. This shows that Flow Sports is not actually worried when a former employee continues to post and write about sports when they leave Flow. More importantly, what it really shows that such conduct is not competitive and that Flow Sports has no legitimate business interest in restraining such conduct. Flow Sports is only subjecting Willie Saylor to its legal wrath because his opinions clash with Flow Sports management directives during his employment with Flow Sports, and because he maintains a channel on Rockfin Martin Floriani's website. Flow Sports has not been damaged by Willie Saylor's Matt Scout's channel on Rockfin. The bulk of Flow Sports damages theory is based on the assumption that Willie Saylor would have stayed at Flow Sports for 4 more years, which the evidence will show is false, and that he is irreplaceable. In other words, Flow Sports readily admits that it failed to take any steps to mitigate its damages. But more than that, the evidence will show that 420 subscribers have canceled their Flow Sports subscription and joined Rockfin. And of those 420, only one person out of 420 said they were switching to Rockfin. The remaining 419 canceled because of a technical issue.
Because this is all confidential. This is from the subscriber list exchange.
All right, well, let's move past it then.
Okay, I'll move past. The evidence will show that perhaps Saylor's content on Matt Scouts drives actual interest in Flow Sports events. After all, there are many Rockfin subscribers that joined Flow after Willie left. And there are many, many, many Rockfin subscribers that are subscribers in common with Flow Sports. Your Honor, at the base of this lawsuit is this. Willie Saylor is a journalist, and he's a noisy and opinionated one. Not to be mean, Willie, but he sometimes runs his mouth before he thinks about his words. He's a critic. He speaks his mind. He pushes his opinion. He's provocative. He does written editorial comment. This is not a character or a persona he developed at Flow Sports. It is who Willie Saylor is. Flow Sports does not own his personality or his brain, whether it's the greatest or not. This is the very thing that the evidence will show they did not want at Flow Sports. They didn't appreciate his criticism. They were worried that it would drive away their people that they had live events contracts with. They didn't want him doing it. They instructed him not to do it because it upset the organizations that they had deals with when Willie criticized them. In fact, the evidence will show that his unfettered criticism of journalism at this point generates interest and conversation around sports events. The court should find that there's no liability, dismiss this case, and dissolve this injunction. Thank you, Judge.
Mr. Soltero?
Thank you, Your Honor. May it please the court and counsel. The evidence will show that Mr. Saylor, an at-will employee, left on November 3rd after a series of conflicts with people at Flow Sports who tried to muzzle him. The evidence will show that within a day or so, all access to their supposed trade secrets that are highly confidential were shut off. As a matter of fact, Ms. Burgess showed during the PowerPoint presentation, the usage by day ends on November 3rd because Mr. Saylor had no access to that information after that. He has not misappropriated or stolen any trade secrets. The plaintiff has come into this court with a narrative that is at a minimum exaggerated, that is factually inaccurate, and done taking things out of context in order to get extraordinary relief, which it has in December and then again in January. Mr. Saylor was enjoined effective December 18th, the TRO, and has been since then. The evidence will show, Your Honor, that this is one of those extremely rare cases under the Trade Secrets Act that the legislature expressly provides that attorney's fees are appropriate for a defendant who is harassed and inappropriately brought a trade secrets claim against. I have a very short PowerPoint. To show the court some high-level issues. First of all, Your Honor, 2019 was a critical year. This is the year where conflicts continued to arise and emerge between Christian Piles, Mr. Saylor's direct supervisor, and Mr. Machuca, supervisor one level up, and Mr. Saylor. In fact, they put him on a performance improvement plan There were numerous cases when Willie Saylor made critical comments that were not perceived to be in Flow Sports' business interests, and they tried to reprimand him or tell him otherwise that he shouldn't be saying these things. This all came to a head in late October, early November, when he made a criticism about a college program. And as a result, they clamped down on him, told him that this was a problem, and Mr. Saylor said, "That's it, I've had enough." Like I said, the next day they cut him off. Shortly thereafter, they sent a private investigator to his house in Pennsylvania, where he lives with his mother and stepfather, and have engaged in a series of inequitable conduct throughout this litigation. That was all before the temporary injunction, Your Honor. So what's happened in 2020? Flow Sport retaliated by taking away his stock options. They did not give him stock options as the affidavit filed with this court suggests in 2014. The stock options awarded were 2 years later, and shortly after the injunctive relief in this case, the board of Flow Sports, in a retaliatory effort, took away his stock options, which is the basis of our counterclaim. And I think the evidence will be undisputed on the math that constitutes the damages for that. What's happened in 2020, we all know COVID has impacted every aspect of everybody's life. And this case and people who are in it are no exception. And because of COVID hitting in early March, there have been no live events, which is the core business of Flow Sports. To the extent Flow Sports has had any problems or issues this year, they relate to the lack of live events and problems they had with women's issues surrounding a wrestling event, one of the rare live events that occurred in July of 2025 that was very publicly well known. One other factor, 2020, Your Honor, November 3rd, 2 days ago, the non-compete PIIA expired on its own terms. The evidence will show, Your Honor, that there's no TUTSA violation, the Texas Uniform Trade Secrets Act. There's no way that Mr. Saylor improperly acquired anything that they claim is a trade secret. The evidence will show that what they claim to be trade secrets are at best dubious and not trade secrets, or at a minimum, all access to what they're contending is a trade secret was cut off after November 3rd, 2019, with one exception that I'll get to in a second. Of course, the law is clear that general knowledge, experience, and skills that an employee has are not a trade secret, and he has not misappropriated anything of that nature or commercially used it, and the evidence will show no damages sustained by Flow Sports. So what did they claim Mr. Saylor allegedly misappropriated? First, they talk about Periscope data. The evidence will be clear. After November 3rd, no access to it. Salary information. Your Honor, I think Your Honor saw this, but it's going to be incredible that their entire claim rests on a tweet where not even any actual salary information was discussed. In addition, they claim confidential information, analytics, all these things, and we've tried over and over again through the course of this litigation to pin them down to tell us what is it that you think he has taken, and they never can. And then the story shifts, and the confidential information or analytics all were shut off by November 4th. Rights holder or customer data, there's not a single live event that they've lost through anything that Willie Saylor has done, and there's no evidence of any misappropriation there. So the one exception, Judge, that they talk about is rankings, which of course he's allowed to do under the injunction, and which aren't trade secrets, because rankings by definition are public. Rankings are things that everybody knows about on the internet. And if there was a formula for coming up with rankings, if there was an algorithm, a secret sauce, et cetera, then they could possibly have some basis here. But there's absolutely no algorithm, absolutely no secret sauce. What happens is that Mr. Saylor, who has an encyclopedic knowledge of wrestling and has been doing this from before he even came to Flow Sports, and for 2 years at Flow Sports without the non-compete PIIA, watches a lot of wrestling, comments on it, and gives us sincere opinions. The spreadsheets that they now think are a big deal, or they're making a big deal out of, are basically Mr. Saylor's spreadsheets. They're his Excel spreadsheets that he uses for all sorts of reasons and notes. And he did that while he was at Flow Sports. He did it before he was at Flow Sports, and he's continuing to do it now. Absolutely not a trade secret, nothing wrong with that. So with regards to the non-compete, Mr. Saylor and Flow Sport do absolutely different things, which is why he left. He was complimentary in some ways, and he is still complimentary in that some of the things he says publicly actually help drive traffic to Flow Sports. Some of the evidence will show. But we know Flow Sports is like a ESPN, NBC Sports, et cetera, where they stream live events, and then everything they do is around that. The problem is that a journalist like Mr. Saylor wants to comment honestly about wrestling, up and coming programs that may be sliding wrestlers in different classes. What's what fans want to see that's separate and apart from the video. So what's happened is he has not streamed any live sports. He has not worked in the video sports industry, which is the clear language of the PIIA. And instead what's happened is that Flow Sports has time and time again harassed him in immeasurable ways throughout this year. The ending of the relationship is telling. And this is, you know, he said, final straw, I'm out. When did Mr. Saylor say this? When he was giving a candid opinion about a program, and he was told that he shouldn't do that because that was somehow going to hurt them. And they're claiming that that's somehow, that what he was then saying and they didn't want is somehow competitive. With regards to the solicitation claims, Your Honor, a separate part of the agreement. Texas law is clear. I've cited two of the cases here, the Eurocat and the In re Athens case are the two leading cases. Solicitation doesn't mean to ask, because otherwise every time somebody posts on LinkedIn or Twitter or Instagram or any social media, that would be, quote, solicitation. That's not what the law is. That's not what it provides for. And the evidence will be that Mr. Saylor has not solicited, has not asked people to cancel anything, subscribers to cancel with Flow Sports. And there will be no evidence of that and no damages. And he certainly hasn't solicited any employees. Non-disclosure is the last part. This is duplicative and redundant of the TUTSA claims. And there's absolutely no evidence that he's shared or disclosed any of this information with anybody, except the one possible exception is this tweet about Ben Askren, who, by the way, Judge, Ben Askren is also a well-known commentator who both posts on Flow Sports and on Rockfin, because you can do both without being competitive. What is the remedy that we seek? Judge, there's been an injunction in place. We would ask that it be dissolved. The non-compete has expired on its face. Section 1552 places a limitation on damages. Believe that the court will find, based on the evidence, no damages were caused by any conduct of Saylor. Unjust enrichment is not a proper remedy for breach of contract, and there's no basis for it under the trade secret claim. And finally, Judge, we would ask that Your Honor grant my client, Mr. Saylor, what they told him they were going to give him under our four theories of our counterclaims, the value of his stock options, that we ask that the bond be released to Mr. Saylor, and finally, with considerable humility, but very appropriate, we would request that the court award attorney's fees to Mr. Saylor for the bad faith of the trade secret claim for the exact reasons the legislature has provided for in the trade secret statute. Your Honor, we look forward to presenting our case finally and being able to tell our side of the story. Thank you for your time and your attention.